Ethan Nordean, another Proud Boy, is filing a motion to cross-examine an FBI agent by the name of Nicole Miller. Now, we learned from her previously that she was the person who was supposed to turn over spreadsheets. She testified, and after her testimony, she was supposed to say, "This is how I know that I communicated because I have all of these logs." You see this written here. Agent Nicole Miller testified that she compiled her link messages in an Excel spreadsheet. But when we got those spreadsheets, it turns out there was about a few thousand rows that were hidden. And so the question was whether she withheld from prosecutors these link messages, right? And these were all the spreadsheets. And we went through these in detail last week. Here's one example. This might solidify the conspiracy charge. That means it's pretty weak. So they're digging around trying to find something to solidify the conspiracy charge because it's absolutely weak. Here's another one. You need to go into that confidential human source report you just put out and edit out that I was present. Oh, that's a problem. We might want to see more about that. Here they're talking about Aaron of the Bloody East, a potential confidential human source. Says, I don't see any emails from Aaron past the 6th, even though there are emails as late as yesterday. Talking about foreclosures. So the defense wants to know about these topics because they directly implicate what they say is their clients. They want to cross-examine this person about this. So they filed that argument. They said, Judge, we are going to impeach this FBI agent. Here is their new notice of argument along with a response from the government. So this got filed by Ethan Nordean's defense team. And this motion is being written by the Smiths, Nicholas Smith from Virginia and New York. Here's what this one says. 10 pages, March 12th. Government against the Proud Boys, Ethan Nordean filing this motion. Now, this is Nordean's notice of argument. He wants to cross-examine the FBI agent. Here's what he writes. The court last week ordered parties to file any arguments by noon today about whether we are going to be able to cross-examine FBI agent Miller's link messages. And so at noon exactly, the government filed their 18-page brief that makes new factual assertions about these messages, including claims about why they do not mean what they appear to mean. They say that Nordean will attempt to respond to those new arguments today. But in the meantime, here's our response to last week's issues. Last week, Special Agent Nicole Miller was up on the stand, and she was cross-examined as follows. One of the defense lawyers says, Agent, one of your obligations as an FBI agent in this matter is to provide prosecutors with written statements that you've made that relate to your testimony. Isn't that right? And she says, yeah, it is. Okay, and you understand that that's a legal obligation, don't you? Yes, I do. And there's a law that imposes that duty, right? Yes. And you said you complied with the government's request to produce your link statements relating to your testimony, didn't you? Yes, I did. Okay, agent. Now I have a question for you. Did you withhold any statements that relate to the subject matter of your testimony that you made in your link messaging system? No. So you provided every single statement that you made in link to us? Yes, I believe I did. You didn't withhold link messages about whether a conspiracy exists in this case? No, not that I'm aware of. And you didn't withhold link messages about whether Aaron of the Bloody East was not involved in planning the chats? No, not that I'm aware of. Okay, and you also didn't withhold link messages about whether inaccurate, confidential, human source related information, should be disclosed over to us, the defense, did you? No, I didn't. Okay. Have you ever gained access? Let me ask you this. Have you ever gained access to the contents of attorney-client communications involving a defense trial strategy in this case? No, not that I can think of, no. So another agent didn't tell you that he had gained access to attorney-client communications? No, not that I can think of, no. Well, she's totally innocent. Wow. Now, as the court knows, says the defense, the government produced to the defense an Excel spreadsheet containing jank statements that Agent Miller compiled for her testimony from the link messaging system. Now, the sheet contained approximately 25 rows of link messages. However, once we got the file, a close examination of the agent's sheet revealed thousands of hidden Excel rows of link messages, over 11,900 in total. So Nicole, she's like, oh, I'm just going to get all these, file, export, link, export, all the file. Oh my gosh, that's a lot. Let me make sure that I have nothing in here that I don't want to disclose to the defense. And she's going through this. Oh man, like most of this is pretty bad. Okay, how about this section? This is all they need to see. All right, highlight all, shift, select those, hide all, boom, all of the rows go away. Oh, this looks good. Perfect. Okay, so here's 25 rows of my evidence that is actually related to this case and that I think is related to this case. All of the other bits of it has been hidden now. Here's your file. Defense attorney goes, this is weird. It goes from 1 to 25 to 11,927. You go, that's weird. Unhide 11,000 rows of new materials. Much of it applies to your case. Yikes. The hidden link messages were mostly sent from other agents to Miller rather than from Miller to other agents. However, even a passing glance at the hidden messages that went to Miller revealed messages from Miller. That's because the agents communicating with Miller in the hidden exchanges can be seen responding to messages from Miller, which were absent even from the hidden Excel rows, right? So like when it's almost capturing the reply. These missing messages were plainly Jenks' statements as they related to the subject matter to which she testified. And remember, Jenks, if you talk about something sort of substantive and you're referencing something, then the defense can say, I want to know what you referenced when you were up there on the stand. Can you please provide that to me? And then they've got to do it, which is what happened here. Now, whether or not missing messages formally constituted Jenks materials, however, they plainly contradict her statements. So when Nicole Miller was up on the stand, they asked her, you didn't withhold link messages? Asked her all of those questions. And another agent didn't tell you that he had gained access to attorney-client communications about a defendant? And did you withhold messages? At this point, when this testimony was going on, the judge said, all right, enough at this point. Stop the proceeding. At this point, cross-examination was stopped and the jury was sent home prior to the end of the trial day, right? The judge didn't like these questions. So the judge said, it's 4:30. You guys can go home now, because he didn't know what to do about it. Because this defense lawyer, shout out to this defense lawyer, Smith, says, oh, you didn't withhold link messages about a conspiracy? The jurors are like, what the hell's going on right now? This is crazy. Because this defense attorney's beating the heck out of this woman. You didn't withhold link messages about whether Aaron of the Bloody East was not involved in planning the chats? She goes, and you didn't withhold link messages about whether inaccurate CHS related information should be disclosed to the defense? No. Freaking out. The judge says, all right, enough. All right, go home, everybody. Go home. Now, the following day, an attorney for the government appeared in court and requested an opportunity to question Agent Miller outside the presence of the jury and right in the middle of her cross-examination. So they got to fix this person. Like, uh-oh, we're in big trouble now. So now the questioning went as follows. Okay, question. An attorney for the government requested an opportunity to, so this is government prosecutor now questioning government agent. All right, Special Agent Miller, link exists on the FBI's classified systems. Is that correct? She says, yes. Objection. All right, objections, they hash that out. The next question comes out from the government to the government, says, did the cover memo to that link message spreadsheet that you turned in, did it advise you that, did the cover memo advise you that the spreadsheet before it was reviewed was classified at the secret no foreign level, question mark? Objections. So Special Agent Miller is another question. When you received the spreadsheet of messages back from headquarters, what was the overall classification level of that spreadsheet? Oh, she gets the right answer this time. Perfect. She says, oh, that was secret, no foreign. Secret, top secret, ultra classified. He's like, yes, perfect. You got it. Great job. We're going to give you a star for the refrigerator when you get home tonight. Finally, Agent Miller explained how she received and compiled her link statements for the production to the government. Okay, now, Agent Miller, do you recall the steps that you took to review the spreadsheet before you provided it to the U.S. attorney? Yeah, I believe I do, yeah. And then another answer, she says, well, so there was over 15,000 messages. So I filtered by what I sent because it was the information, my statements. So what I sent, and then I went through those messages, and anything that was relevant, any statement I made is what I provided to the U.S. Attorney's Office. That's that's your FBI. I just search, I did a Control F search, sent on this day, highlight those messages. Here you go. So then they cross-examine Agent Miller about this. So the defense is up now. They say, all right, Agent Miller, and you didn't remove any other, you didn't remove any messages of yours from the spreadsheet that was given to you by FBI. So you did an export, they did an export, they sent over to you. How'd this work? She says, well, what do you mean by, I didn't remove anything, but I took some statements that so if anything was related to this investigation and to what I was testifying to, those were provided. Some of the internal conversations regarding administrative things, as far as case files and adding things to case files, that wasn't provided because it didn't relate to my testimony or to what we're doing. Like administrative things. Agent Miller concluded this testimony, and afterwards, Nordean apprised the court that while the witness testified that there were over 15,000 messages in her link message spreadsheet, the version received by the defense contained 11,959 rows, not all of which contained messages implying 3,000 missing rows beyond the thousands of hidden rows. Over 15,000, so even her testimony now at the back end is still bad. So now that all of that is clear, they say that the court ordered the defense not to review the rest of the spreadsheet. Hopefully they had already done that by the time they brought it. Hopefully they'd already done their analysis because, classification now. Oh, it's classified. Pending a classification review, on March 10th, the government delivered a cleared version of the spreadsheet along with a cover letter. Among other things, the letter stated, it appears that based on Miller's testimony that she filtered this spreadsheet. And then deleted those messages that appeared to either be classified or not subject to production. Now, at the time the government produced this document to you, it was not aware that it contained other messages made by other individuals that were by definition not the subject to production under the Jenks Act. So it's just a bad filter and it's just a miscommunication. Sorry, you got all of those details. Now, as for the classified material, the letter states that the classified document that was originally produced to you contains about 12,000 rows. A number of those rows, however, contain no message content. The government has deleted those rows, leaving only the rows that contained a message sent to or from Miller. The government also deleted the index tab. Finally, the government removed 80 rows from the spreadsheet that contained classified information, or here you go, this new made-up thing called other sensitive FBI information, which is this new category that they invented that seems to just be covering up their criminality. Oh, shoot. Do we break the law there? Yeah. What do we file this in? Well, it's not really that. It's not really this. Let's call it sensitive FBI information. It is sensitive after all. If people knew about it, they'd want to prosecute us. Great idea. Special agent, you are special. Put it in the filing cabinet. I love it. So none of these messages were authored by S.A. Miller. The cleared version of the spreadsheet contains 5,000 rows. The government will provide a court copy of all the rows in the cleared spreadsheet. Now, the government's letter, this is the defense, demanded that the defense destroy any copies of the original spreadsheet. So defense counsel received the letter 1:44 p.m. At 2:15, Nordean asked the government to explain what evidentiary privilege would require defense to destroy a discovery production containing sensitive FBI information and what that term meant. Shout out to the defense. That's great. All right. So they sent a letter over there. Oh, we'd love to comply with this. We'd love to work with you here and destroy whatever you want us to. However, this is discovery in a criminal case that we're working on, which is weird that we have to destroy our own discovery here. That's a problem. And it's also something involving this new thing you guys made up called sensitive FBI information. Can you please help us understand what that means? We looked it up on Google and we can't find it. Now at 2:19, Nordean inquired of the government how many of the 80 rows deleted by the government contained classified information and how many contained other sensitive FBI information as well. He also asked the government to identify which rows were classified and which were sensitive FBI information that you just made up, that we'd love to know what that means. Because we want to see what it is. To date, the defense has received no response to these inquiries. That's right. All their lawyers over there at FBI headquarters are still scrummaging around trying to figure out what to do about it. The government has proffered no evidence that a single row of Miller's spreadsheet contains classified information. And if they did, this is another classified document scandal. I mean, my goodness, they're everywhere. As indicated, the government's latest production included unclassified messages. Nordean had flagged for the court a link exchange where another agent in this investigation appears to direct Miller to remove his name from a report. In the original sheet, there were no visible messages from Miller in response to that demand. The government's updated Miller production shows Miller's messages. So we see the counterpart to that. She says, fixed. Okay, signed. Thank you. No, thank you. You need to go into that CHS report you just put out and edit out that I was present. For which one? The most recent one, CCU. And then it looks like the messages are sort of out of order here. Fixed, signed, thank you, no thank you. Yeah, interesting. So interesting. So the first one didn't have these first lines. Like this is all new, this top section here. Now, after the agent states, you need to go into the confidential human source report you just put out and edit out that I was present, Miller says, for which one? The most recent one, he CC you. So Nordean asked the government that the government produce the messages following for which one. The government declined. They say, you don't need that. So the defense wants to know that. What is the one they're referencing? Which one? Government says, you don't need to know that. Nordean moves the court to order the government to produce the messages, at least for the judge to review it so that we could enter this into the record at least under seal. Now, on the evening of March 10th, the government emailed the court copying the defendants, asking for permission to share the updated link material with Miller before she resumes the stand. Including the government's letter signaling its position it was Miller, not the U.S. Attorney's Office, that deleted any of her link messages. We have some brief argument. They say that Nordean expects the government to file a motion seeking to bar his use of this material, that they don't want him to cross-examine Miller on any of these things, calling it all outside the scope. We're going to get to that motion next. But they say, as she herself testified, Miller has a legal duty to produce to the prosecutors her statements. She testified she understood that duty. She testified she withheld no statements. She testified another agent didn't tell her that he had gained access to attorney-client communications. She testified she did not withhold link messages, but she did. She even deleted messages from her spreadsheet about those topics. The government admits it. So whether the agent gave truthful testimony about her legal obligations related to her work is a matter of credibility. The government's suggestion that any of this is outside the scope of a direct exam is a non sequitur. Rule 611 explicitly states that matters affecting a witness's credibility are not even analyzed under the scope of direct framework. For cross-examination should not go beyond the subject matter of the direct examination and matters affecting the witness's credibility. In other words, the defense wants to be able to beat her up about every one of those lies. There is no argument about this being collateral. You see here, it is directly related to her testimony, and so they're asking the judge for permission to argue over this. Now, we're going to see what the judge does about this in a quick minute, but I want to show you the government's response as well, because they are responding to that motion, and you can imagine it's going to be a lot of the same, so we'll fast forward through it. But here's their response. They say, the United States Attorney's Office says that our FBI agent is amazing. They write, at the end of the day on trial, counsel for Nordean asked FBI Special Agent Nicole about questions. And there was a spreadsheet problem that popped up. But later that evening, we solved it all. We know what happened. One, she received a complete spreadsheet from FBI headquarters. She filtered the spreadsheet so that only her messages were visible. That's all, not a big deal. And she removed any messages that were classified and not relevant. Oh, that's it. And then on March 10th, the government reproduced its original production, less 80 rows. Yes, those were classified. Yes, they were sensitive. And the government's reproductions are significant overproductions. We do not believe that the vast majority of the messages we were even required to be produced. And so the court should now limit the scope to prevent them from digging into any of that. All right, you see how this was? So it's classified, so you can't use it. It's not relevant. It's an overproduction. So we gave you a lot more than you needed anyways. And you don't need that. So it's outside the scope. It's not relevant to her particular charge. She filtered it. This was all above board. There was no wrongdoing at all. She didn't delete anything. She just deleted the classified materials or wanted to and filtered it out. No malfeasance at all. And so, judge, you should limit all of this. Anything that they want to explore about those messages are outside the scope. You see where that argument's going to go. They say that it's only limited to her direct testimony. So if she didn't talk about it during the direct exam and they want to talk about these other confidential human sources or whatever, they say that's not even related. So they're going to put it outside the hula hoop in that manner. We have another argument. They say if a prior statement relates to something outside the scope of redirect, it's excludable under Rule 403. Very important rule we talk a lot about here. Whether something is more probative or more prejudicial. It's kind of this balancing test. We call it a 403 balancing test, where on the one side you'll say, all right, this evidence is really, really, really harmful if they hear about it, right? If the government is found, if this FBI agent is found to have been lying and hiding evidence and manipulating evidence, you can imagine how harmful that would be to the jury. Very harmful to the government in its case. And so oftentimes this works the other way, right? The defense doesn't want some evidence of like a prior criminal charge to come in, because if the jury heard that they murdered somebody 10 years ago too, that would be very bad for them, right? So they keep that stuff out because it's just too far removed. So here, if the jurors hear that the government lied about this stuff, big deal. So now we have to say, all right, is it worth it? Is it important enough? Is it related to the case enough that they should hear that because it's more probative than it is prejudicial? Probative meaning it tends to add value to the determination of the outcome. Does it aid the trier of fact? Does it aid the jurors in coming to a conclusion? If it does, and it's prejudicial, that's okay. We'll let it in. But if it doesn't aid them and it's only prejudicial, we're not going to let it in. So the government is saying, the fact that our FBI agent is being called a liar, it's going to be really bad for our case. And judge, you got to keep it out. Here is what they're saying. It's not attenuated enough. It says it has no real probative value. They say it's unfair and it's prejudicing the government. As the court has already explained, it's improper to elicit testimony about an agent's opinion. They say, like all other reports, confidential human source reports are reviewed for accuracy. You need to go in and make that adjustment. It's just routine. That's all it is, man. It's not even a big deal. Agent Miller responded for which one? The message referred to an email sent by the CHS, who is an online researcher and not even a member of the Proud Boys. So he didn't realize that he was copied on the emails. And so somebody got copied on the emails. And so if they are copied, then they're not present for purposes of the email contact. And because of FBI policy, he cannot approve a write-up of the source. It's just a miscommunication, everybody. Oh man, another one. Man, all these miscommunications, nothing went wrong. In short, the exchange concerns a routine clerical matter, and it does not suggest any wrongdoing on the part of the FBI generally or of Agent Miller personally. So stop asking for us, okay? We never do anything wrong. Now, the destruction of other evidence. They say, as the court knows, disposal of evidence is routine and part of the life cycle of every criminal case. And so the destruction of evidence related to these 338 items of evidence from a nearly 20-month-year-old multi-co-defendant trial is not even a big deal. The special agent disposed of this evidence by returning it to family members or otherwise destroying it. It was not related to this prosecution. And it's just confusing. And so don't let the jurors hear about this, because if they hear that Agent Miller was destroying evidence, they're going to think it's about this case. And trust us, it definitely was not about this case. It was about another case from a couple decades ago, 20 years old, I'm sure. Now, the court, they say, has the power to exercise reasonable control over the examination of witnesses. And you see the rest of this is the rest of the government's explaining why the defense should not be allowed to talk about any of the things. So for the foregoing reason, the court should limit the scope of Agent Miller to only evidence from J6 from midnight to shortly before 5 p.m. and should preclude cross-examination from anything else. Signed here by a couple of U.S. attorneys, Connor, Eric, on behalf of Matthew Graves. Here's where they're saying that they acknowledged and waived their attorney-client privilege. So the TrueLink system, the department may monitor any activity on the system. So if you and your lawyers are talking on this thing, we're listening, and you acknowledge you waive your attorney-client privilege. They're saying, Judge, you should just crap all over that very important privilege because it serves the government here or something. So that is the government's response as well. And you can see we're going to have to wait for the court to issue rulings on these items.